It's funny in the webcast, my right is my left, so I'm all goofed up. Welcome, welcome, welcome. Lecture 10. We're almost done. We'll get started in about 5 minutes, but I like to cue in so everybody can see, make sure that all their computers are functioning correctly. But we're winding down, folks. We're almost there. Hopefully everybody has been following along thus far. If you've had a chance to take a peek at the supplemental material that we have, I encourage you to do that. There's a lot of as a matter of fact, we're selling the homework packages now for everybody that is interested in getting some of the supplemental material. We're selling it at nearly 50% off here at the Institute on the Constitution. You can go to theamericanview.com. You could give me a call. You could email me. Or you can also call the 800 number here, which is 866. I should probably have it memorized, but because it's on speed dial, I have no need to memorize it. Let's see here. Of course, the 800 number is on the AmericanView.com as well, but it's 866-730-9796. So you can get the supplemental material, the homework package. I think the homework package is valued around $100. If you buy it individually, we're selling it for something like $60, I believe. Maybe it's $50. But anyhow, reach out to me for that because there's a lot of videos, DVDs, things like that are really great that go along with all of the learning that you have today. That's going to dive in a little bit more, get a little bit more in depth to kind of help formulate some of these ideas. Get started here in about 3 minutes. Also, too, if you'd like to follow along, you can go to the Institute on the Constitution Facebook page, where we are. Michael is what do we call him? He does commentaries. You can't really call him a columnist, even though that's essentially what he is. He writes commentaries every week and does videos for him, and he's published on a variety of different outlets. But we do memes and stuff like that for Facebook, but we also share these commentaries that are about 2 minutes long, and they kind of dissect a lot of the just simple principles, those tidbit things that people can grasp really quickly, and once they got the meaning, it's like one of those epiphany setting trends here, and we share those every week as well. And there's also a YouTube page where you can get a lot of those videos that we're feeding as well. Shot right in this studio, actually, that I'm in right now here in Maryland, just outside of the Beltway. So we got about 1 minute and 15 seconds. Too many options is right, Janet. Too many options. And just when you learn the options you think you're supposed to know, new ones appear. Okie dokie. We are ready. Lord, we thank you for this night. Thank you for the blood of your Son, Jesus Christ, Father, which gives us the liberty that we speak of tonight, Lord. And I pray that you substantiate and solidify within our hearts that we may go as you have commanded us to do and to make disciples of men in this America, these United States of America, Father. Thank you that those blessings of liberty have been perpetuated to us, Father, and that we have the ability and the grace to carry them forward to our posterity in Jesus' name. Thank you, Lord, that we are found under your covering, under your shadow. Lead, guide, direct us, and teach us this night. In Jesus' name we pray. Amen. All right, as always, we'll start off by correcting the test from Lecture 9. Number 1 of the two interpretations of the Second Amendment. The blank view is what the framers intended by the Second Amendment. Of course, that's the individualist view. We have individual liberties. Number 2, the problem with the collectivist view interpretation of the Second Amendment is that D. It is out of place in the Bill of Rights, which protects individuals. And it's the whole purpose of the Bill of Rights. Number 3, the purpose of the Fourth Amendment is to protect against C, the invasion of privacy. That was number 3. Number 4, the Fifth Amendment provides that a person cannot be tried, C, twice for the same offense in the same jurisdiction. The Fifth Amendment prohibits compulsory blank and provides that no person can be deprived of blank, blank, or blank without due process of law. That is B, self-incrimination. It prohibits compulsory self-incrimination. Provides no person can be deprived of life, liberty, or property without due process of law, thus making abortion illegal. Number 6, the First Amendment provides that C, private property, cannot be taken for public use without just compensation. Eminent domain. Number 7, the Sixth Amendment secures the rights of C, criminal defendants to, notice we're defendants at this point, to a fair and speedy trial. Once convicted, there's no rights guaranteed to that criminal defendant. Number 8, the Seventh Amendment, like halal meals for Muslims on death row because freedom of religion. Now you're in prison, buddy, you gave up your freedoms. You'll eat whatever we put before you, or you can starve to death. That's your choice. You're the criminal. The Seventh Amendment provides the right to a D, jury trial in cases involving common law and exceeding more than $20. Number 9, the Eighth Amendment, that was D. Number 9, the Eighth Amendment provides that criminal punishment must not include either excessive C, bails, or fines, nor cruel and unusual punishment. But again, it does not negate the death penalty, located in Article 5 of the Bill of Rights. The Ninth Amendment specifies that the enumeration of certain rights in the Constitution shall not be construed to deny or disparage others retained by the D, people. So quick run through. Number 1 was C, number 2 was D, number 3 was C, number 4 was C, number 5 is B, number 6 is C, number 7 is C, number 8 is D, number 9 is C, number 10 is D. The 11th Amendment, moving on. Oh, wait a second. There's no true and false in this section. I forgot about that. No true and false. So we are on to the next section, which will be Lecture 10. So if everybody could move there in your notebooks. And we're going to start off with Thomas Jefferson, because he acknowledged something that is found in your Bible. Now this part excites me because I love showing or teaching in how the Bible, which was first, because God our Creator was first, is integrated into the constitutional system, which we can trust every area where it is. Where it's not, obviously we can't trust it. It's not an infallible document. But the parts that acknowledge the Bible and rest upon the Bible for their authority, we can trust, we can depend upon, we can rely upon. Why? Because we can trust and rely upon the God who gave us His Word and also gave us civil government. Thomas Jefferson said the God who gave us life, gave us liberty at the same time, were created. Can the liberties of a nation be thought secure when we've removed the only firm basis? What is that basis Jefferson's referring to? A conviction in the minds of the people that these liberties are the gift of God. Can our rights be secure when we have removed that from the minds of the people? That they are not to be violated but with his wrath? So let's just say that these rights cannot be removed because they're God-given liberties. But let's just say we forget. Oh, well, we forgot. No. Step 2 of what Jefferson is saying is that they cannot be violated but by his wrath. You can expect wrath. God is a living God. He does not sit dormant out there like a scarecrow saying, you better not enslave my people. You better not do bad things. There is wrath that's incurred when you break his commandments. So Jefferson is speaking that. How can we have liberty? And how can our liberty be secure if, in the minds of the people, we've taken away the conviction that these liberties are a gift of God, number one, and that if these liberties are violated, the wrath of God abides upon those that violate those liberties. We won't have security anymore. Criminals will be emboldened. And God will judge. Unfortunately, the people will suffer for the time. 2 Corinthians 3:17 says, where the Spirit of the Lord is, there is liberty. So where the Spirit of the Lord is, that's where liberty is found. We don't say, oh, we're going to have liberty now. Come on over, Spirit of the Lord. Where the Spirit of the Lord is, there is liberty. It's always found there. It's like Jake Macaulay, wherever he's present, his hair is with him, his eyes are with him, his nose is with him. All my faculties, some people might say, well, my head's not on some of the time, to be funny. But the fact is that where the Spirit of the Lord is, there's liberty. It's inevitable. The two are inseparable. And that is our source. This is an acknowledgement of God, and that our rights come from him. Where the Spirit of the Lord is, there is liberty. So where we acknowledge there is a God and our rights come from him, we have liberty. If we don't have that, the Spirit of the Lord, or as Jefferson said, if we remove from the minds of men a conviction that liberties are a gift of God, we're not going to have liberty. So he's echoing Scripture here. Scripture tells us where the Spirit of the Lord is, there's liberty. In other words, where we acknowledge there is a God, our rights come from him, there's going to be liberty. Where government moves away from that, there's not going to be liberty anymore. Michael Bruca said, therefore, summarizing what Jefferson and the Bible say, anyone who has studied law, now this is spoken from a lawyer, somebody who went through law school, the University of Baltimore Law School, anyone who has studied law, quote unquote, who has not studied the Bible, has not studied law. How can you say, I have studied law, if you have never read and studied the Bible? Unless you're reading from people in law, commentaries, for example, of Blackstone, but he's citing the law. He's citing the biblical authority of law. If you haven't studied the Bible, you haven't studied law. And no law schools study the Bible. Just an FYI. So are they really studying law? The 11th Amendment, we're going to go into this because we're going to talk about all the amendments. We've talked about the Bill of Rights. We did Article 1 in lecture number 8. Number 9, of course, was 2 through 10. I wore my gun show shirt. If you want to get those, I'm not going to sell you mine, and I have no idea where you can buy them from. Maybe you can create your own, I guess, and trend it. But we're going to start with number 11. Now, 11 deals with an issue that most of us aren't very concerned with. Some of these I will breeze over, but I'm not saying they're not important. What I am saying is I want to really cover in depth those things that we deal with on a day-to-day basis. The 11th Amendment covers the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by a citizen of another state or by citizens or subjects of any foreign state. So the states could not be sued in federal court by citizens of another jurisdiction without the state's consent. This amends Article 3, Section 2, Clause 1, which allowed such suits. So we've amended the Constitution the way that the Constitution prescribes, as Washington said, not by usurpation. This results from the reaction against a lawsuit against a state of Georgia, from a gentleman, and you can read the details right there below. I encourage you to do that in the notebook. I'm not going to cover those right now because they're written for you to read, and I'd like to cover other topics a little more extensively. But know that we amended the Constitution there. We've still limited federal power. We've not aggrandized any power to the federal government through this amendment. The 12th Amendment is the Electoral College, and you can read through the wording of that amendment, but the importance to understand, it's a fairly long one, the importance to understand is that this amends Article 2, Section 1. It's to provide that electors should vote separately for the president and vice president. Up until that point, the Electoral College would cast their votes for one candidate for president. The top vote getter would get the presidency. The second in line would become the vice president. Now, what happened in the election of 1800, this is where Thomas Jefferson was vice president at the time, beat John Adams, who was the president, and there was a tie between Aaron Burr and at that particular point, when the presidencies changed, there was no new political party. Both of them worked together. But now we're starting to get more of a rift as we have more liberty. We've got a little more security, a little more prosperity. People come with their own ideals, and we start to internally, there's conflicts internally within our own country. Whereas before, we had a common enemy, so we knew who we were fighting, and we stayed away from fighting with ourselves, at least to the extent that we now began. So in this election, the 1800s, it's referred to as the Revolution of the 1800s. Vice President Thomas Jefferson defeated John Adams. The election was a realigning election that ushered in a generation of Democratic-Republican Party rule and the eventual demise of the Federalist Party. So the Federalists were used for a certain extent to a certain period of time, 3 terms, 12 years. And now those days are over. Jefferson's on the scene, and his party rose with him. This election exposed one of the flaws in the original Constitution. The members of the Electoral College could only vote for president. Each elector could vote for 2 candidates, and the vice president was the person who received the second largest number of votes during the election. Typically speaking, now they're voting for 2 candidates. Anyhow, the point is that the vice president that you get is going to be a little bit more closer aligned with the president. That's the style of thinking there. Now, these 2 amendments preceded the war between the states, except for Amendment 27, which we're going to talk about. It was never ratified. But as you look, those amendments were there in limited federal power. As you move into the 13th Amendment in 1865, this is after or during the war between the states. The 13th Amendment comes along and says neither slavery nor involuntary servitude except as a punishment for a crime. Notice slavery is still legal through punishment for a crime. Whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. Many people are like, well, don't we got the Emancipation Proclamation? Didn't Lincoln free the slaves? Why did we need this amendment? Well, the point is that the Emancipation Proclamation didn't actually free slaves. It was a political document. And during that time, what Lincoln essentially said through it was the slaves in the rebel territory, in other words, the territory that he had not been able to subdue by force through his military, those slaves could be free. So the states where he had no authority, he freed the slaves. In the states where he did have authority, he did not free the slaves. I know, it sounds crazy. What we learned in school, Emancipation Proclamation, Lincoln gave liberty to slaves. No, he actually technically didn't make anybody free by the Emancipation Proclamation. Therefore, Congress had to come up with the 13th Amendment. Early courts ruled that the 13th Amendment simply abolished the institution of slavery. This is where we get into the prejudice of these United States. And also, too, I want to make note that you'll notice that a usurpation of people's liberties and rights always comes through a loophole. Typically, those loopholes are created by sin, a national sin in this particular case. We have slavery, so we have an amendment now that's going to sneak through, utilize slavery as its opportunity to aggrandize power to itself in the form of tyranny. Now, that's what has become of this. I'm not going to speak directly to the 13th Amendment, but I will cover it. Early courts said that other forms of segregation or discrimination were not limited by the 13th Amendment, just slavery. So in other words, separate but equal. Separate but equal, the case, you can still be separate but equal. why that stood for so long. Justice Harlan dissented in the civil rights cases, argued that the 13th Amendment did more than abolish slavery as an institution. I want you to notice the term civil rights. It's important. What do we have? We have God-given rights. We don't have civil rights. Civil rights implies that we have certain rights from the state. It's not true. Our rights come from God. The purpose of government is to, yep, you can finish my words, thank you, secure those God-given rights. Not to give us rights. My goodness, if we get our rights from them, then our rights are unstable and volatile, and it depends who's in power. There's no security. So I want everybody to notice even right there where you can see a sin comes on, and now the government has to come by and ensure rights. And we delineate from the original meaning of God-given rights, and we get this topic, civil rights. But this man argued, Justice Harlan, that the 13th Amendment did more than abolish slavery as an institution. It abolished the, quote, badges and incidences of slavery that are reminiscent of the slavery era, i.e. segregation, denial of civil rights, etc. Now again, I would rather have God-given rights than civil rights. Notice the Chick-fil-A cup that I'm sporting tonight. I apologize, I've got kind of a sinus thing, so I need to drink water, so from time to time you'll see me drinking water. Keep my whistle wet. Justice Harlan's dissenting view in 1883, he lost, obviously he was dissenting to the majority view, eventually became the majority view. And this was in a court case in 1968. Look how long it took. It took nearly 100 years for the dissenting view, which was correct, to wipe out to become the majority view. Congress shall have power to enforce this article by appropriate legislation. The point that I want to make with this is that we see here the states wouldn't listen, so the federal government had to put in some extra clout to make sure that, yep, here's the amendment, and you can't ignore it, because we can, by force, enforce this article by appropriate legislation, giving themselves some extra power that was necessary because of some of the southern states may have not concurred with it. Now again, it could have been well intended, but that left to generations in the future now gives the government the excuse to bully. Congress shall, the income tax is another one. This also appears in Amendments 14, 15, 18, 19, 23, 24, and 26. So you see all these amendments have grabbed hold of this wording and said, wow, that worked really good for them, it'll work good for us too. Problem is, if we by tyranny or means of by a tyrannical means utilize this phrase, it becomes destructive to our system of government and our rights. The income tax, which is a conscription on labor, and the draft, conscription on the persons, present two bodies of argument indicating that slavery, rather than being abolished, has been expanded to all individuals through the amendment that brought on the income tax. Because what we're saying right now is slavery is confined to one's labor through an income tax. You are forced when you work. So I can make you a slave. I can make your finances a slave to me on your labor. I can make your labor a slavery to me because when I tax your finances, that's a form of slavery. It's involuntary. I can tax your labor. So my labor produces resources which then are taxed. That's slavery. Not by choice. Secondly, the draft. Now, we don't have a draft system intact right now, but we have previously in our country. The draft was a confiscation of one's person. So here we have one's person being confiscated. That's a form of slavery. You're being forced against your will. No different than slavery, chattel slavery. And a confiscation of your labor. IRS, i.e. the 16th Amendment. So what we're saying right now is, does slavery still exist? Then it existed due to the color of your skin. I'm talking about the slavery that we were attempting to eradicate through the 13th Amendment. But nowadays it transcends all colors, all nationalities, and it comes right into your resources and your very person to form the draft and the slavery. So it's something to think about. We can eradicate a threat to our rights on one front, but don't think for a minute that it won't try to come and backdoor it. The enemy always tries to do that. If the enemy can't come in front of your face and beat you backwards, then he'll try to come behind you and push you too far and too hard. The 14th Amendment, this was due process and equal protection. This was in 1868. Notice again, all these amendments, they give federal government more power, as opposed to the original intent of the Bill of Rights was to be a brick wall on the sides of the football field to say, federal government, you cannot move here. This is an impenetrable wall. Congress shall have power to enforce by appropriate legislation the provisions of this article. What essentially this article has done, the 15th Amendment, many people say it's the most destructive amendment since the Bill of Rights. It was destructive of the limits established on the federal and the powers reserved to the state governments. This is how. The states must respect the rights of a U.S. citizen. Now, this is what's happening. This is a watershed amendment, and this is why. Because in the past, the authority was always the state. It was not the federal government. The states contract with the federal government and gave the federal government power, but they were in subjection to those states. The people individually, because the states were comprised of the people, the states protected the people. And the states had no interaction with the federal government. The people in the states had no interaction with the federal government, but through the state legislatures and through the representatives that they had sent to Congress and that the state had sent to Senate. Now we're eliminating that, and we're saying the federal government now has the ability to make sure that the states, they have taken an authority away from the states to make sure that the states stay in check with their citizens. Again, why does this come? The 14th Amendment talks about a whole lot of things. This due process and equal protection to all people. Again, this came through the issue of slavery. So it was going to say that the federal government, when the state does not protect the rights of due process or any of the rights for that matter found in Article 5 of the Bill of Rights, life, liberty, and the pursuit of happiness or property, to people of color, that the federal government would come in and make sure that that happened. Sounds good, but again, left to a citizenry 100 years from now, 150 years from now, what has that been twisted and contorted to become? The states must respect the rights of all U.S. citizens. There's problems in the ratifications of the 14th Amendment. This is where it gets kind of tricky. You'll notice, too, a lot of things that Lincoln did and the legislature did during the times of the Civil War, the war between the states, and afterwards, the ratification process wasn't as smooth. And this is why. It was proposed by an unconstitutional Congress. The United States Constitution provides, Article 5 provides, no state without its consent shall be deprived of its equal suffrage in the Senate. Okay, that's Article 5. The fact that 23 senators have been unlawfully excluded from the U.S. Senate in order to secure a two-thirds vote for adoption of the joint resolution proposed, the 14th Amendment is shown by resolutions of protest adopted by 8 state legislatures. New Jersey, Alabama, Texas, Arkansas, Georgia, Florida, South Carolina, and North Carolina. This is unbelievable, yet it was still pushed through. It was never presented to Andrew Johnson. He even gave a speech about it in 1866. It was never ratified by 3/4 of the states. 15 states rejected it. You can read those states right there. Congress illegally removed 10 southern state legislatures by military force and installed puppet governments, which then, of course, ratified the 14th Amendment. The Supreme Court has never dealt with the constitutional problems in Coleman versus Miller in 1939. The legislature of Georgia, North Carolina, and South Carolina had rejected the amendment in November, and in December 1866, new governments were erected in those states and in others under the direction of Congress. This was called the Southern Reconstruction. The new legislatures ratified the amendment. Wink, wink, what a surprise. That of North Carolina on July 4th, South Carolina on July 9th, and Georgia on July 21st. And there's a source in your notebook there. You can take a peek at all of this. The state may not deprive anyone of life, liberty, or property without due process of law. Now, it continues to get... The Fifth Amendment contains similar provisions for the federal government. This applies to the states now. What's the danger in that? Well, the danger in that is that then the federal government can become the boss man in charge. The courts have subsequently ruled that liberty and due process includes most, now notice the courts, liberty and due process for you and I as individuals. The federal government will then secure those rights too, beyond the state. The courts have subsequently ruled that these rights of liberty and due process include most of the rights guaranteed in the Bill of Rights. Most. Notice I said the term most. Which rights don't they? The Second Amendment. It's as plain as the nose on all of our faces that we have a Second Amendment right. The Bill of Rights is very clear. The right of the people to keep and bear arms shall not be infringed. Period. People. The people of the citizens of the states. The courts rule that you have liberty, you have due process of law, but you don't have a Second Amendment. A little prejudicial? That's the courts I'm talking about. But think about that. It applies to all government actions at all levels, since municipalities, counties, and school districts are subdivisions of state government. Judicially active courts have held that the incorporation doctrine means the Bill of Rights applies to the governmental action at all levels. So you know what, guys? We're just going to take control of all levels. Therefore, if the federal government doesn't feel that prayer is constitutional, therefore your school in your county that you sit as a school board, it's unconstitutional. You see where there's problems? The federal government is not suited to govern individuals, period. It's suited to protect the rights of the people within the states, to protect our borders, to prevent piracy, to coin money, provide for postal roads, etc. It is open to question whether the incorporation doctrine accurately reflects the intent of the authors of the 14th Amendment. Now, here's where we get to it. We see what the 14th Amendment has become, how it's been twisted and distorted. But what did they really intend by the 14th Amendment? Did they really intend to make it as it is the incorporation doctrine, where the states are now become subservient to the Bill of Rights to its citizenry? The failed Blaine Amendment, this particular gentleman, Blaine, was from Maine, amendment disproves the incorporation doctrine 7 years after the 14th Amendment was ratified. Follow me along here. Please watch the webcast if you don't follow this the first time. It can be tricky to understand. 7 years after the 14th Amendment was ratified. This was the proposed text of the Blaine Amendment. No state shall make any law respecting an establishment of religion. Remember, we're trying to apply the Bill of Rights to the states. No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof. We discussed already, there's no religious test from the Constitution. There's no federal denomination. Why? Because many of the states had their own. But Congress shall make no law respecting the establishment of religion. Does not prevent the states from doing so. And no money raised by taxation in any state for the support of public schools or derived from any public fund, therefore, nor any public lands devoted thereto shall ever be under the control of any religious sect. Nor shall any money so raised or lands so devoted be divided between religious sects or denomination. That amendment was rejected. Now, if the purpose was that we incorporate the Bill of Rights to the states, we wouldn't have rejected this wording that was used here. Was taken straight out of the First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, etc., etc. That was rejected. Who was the watchdog at that point? The states were. But now, who has become the watchdog? The federal government and the courts. This was an attempt to, what it was an attempt to is the courts, if the 14th Amendment incorporated the First Amendment against the states, remember we're talking about incorporating, as the incorporation doctrine claims, then the Blaine Amendment would have been entirely unnecessary. The Blaine Amendment wanted more. It wanted to more perfectly direct what courts are going after nowadays, but it was rejected. Therefore, simplifying, the 14th Amendment is not the intent of the framers of it. It's not being utilized as such, but today the courts read into the 14th Amendment what was rejected in the Blaine Amendment. I wanted to make that statement because this is a prime example of us not being sober and vigilant, on our attacks on our liberties. This very thing was rejected, but now the courts have read into the 14th Amendment what has been rejected already by legislatures closely thereafter, saying that the original intent of the 14th Amendment is not what is being twisted and distorted and used by the courts to do. And again, this may take some time. You may go through that again just to understand it a little bit more in depth, because it is tricky to understand, but I think you get the point. States may not deprive anyone of life, liberty, or property without due process of law. Okay? The Fifth Amendment contains similar provisions. So we're just talking Fifth Amendment here. We're not talking any of the other amendments. The courts have subsequently ruled that liberty and due process include most of the rights guaranteed. We already talked about that, most of the rights, of course, except for your Second Amendment right. That the Bill of Rights applies to government action at all levels. States may not deny anyone equal protection of the law. This prohibits discrimination that lacks a rational basis, or, in some instances, a higher standard of proof. Strict scrutiny for racial discrimination. This seems to be more accurately what the framers of the 14th Amendment were going for. However, the 14th Amendment does not apply to purely private discrimination. This state must somehow be involved. It can't be individual discrimination. It makes a person wonder, discrimination regarding, this is my establishment, these are the type of people I want in, etc., etc. Those who aided the Confederacy, this is also in the 14th Amendment, those who aided the Confederacy may not vote or hold office unless pardoned by Congress. Debts owed to Union soldiers are valid. Debts owed to Confederate soldiers are invalid. So there's the fairness of the 14th Amendment. While seeking to liberate certain peoples, it's enslaving others. The 15th Amendment was voting rights for former slaves. The U.S. citizen may not be deprived of the right to vote because of race, color, or previous servitude. A good amendment, I think many would agree. Now, the 15th Amendment stopped after the war between the states, and here we're done. For 43 years, we have not created an amendment. Until 1913, we have the 16th Amendment. Many folks know the 16th Amendment. It's the amendment regarding income tax. Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Why? Because up until that point, Article 1, Section 9, so there's no capitation taxes. So the taxes that were laid were based on the census, and we're going to come into that in a little bit here. Now, many people say, well, I'm not going to take my census. I would encourage you to do so. It is completely constitutional, but you don't have to get into the personal information, your email address, your, etc., etc. There's certain things on that census that you don't have to fill in to protect your own privacy. Congress passed the income tax in 1893. This did happen. Congress passed this in 1893. However, the Supreme Court ruled it unconstitutional. In 1895, Article 1, Section 9 says no capitation tax. A tax on your head. We'll get to that in a second. Congress then passed the 16th Amendment in 1909. Finally, it was ratified in 1913. Ratification problems with the 16th Amendment are in Bill Benson's research, The Law That Never Was. We have that in the back for your homework. Please read this. It's fascinating. How in the world did these amendments ever come into existence? This is what he found. I'm going to give you the simplified version of it. It was not ratified by state legislatures, and so reported 7. So 7 state legislatures, and it was reported, so this is a true fact, did not ratify the 16th Amendment. It was not ratified by state legislatures, but was reported as ratified. 3. So 3 state legislatures did not ratify it, yet on the record it said they did. That brings us up to 10 states. Remember, you need 3/4 of the states to agree before it becomes an amendment. Number 3, the failure of the governor or other official to sign. Although required by the state constitution, there was 6 of them. So an executive officer did not sign the amendment. That was 6 states. So all you need is 13 to kill this bill, and we've already exceeded that. We have 16. But yet it's still carried. Number 4, there was other violations of state constitutions in the ratification process. So they violated their own constitution in ratifying it. 25 states did that. Approval, but with change in wording. So many states, 22 of them, did change or did approve the income tax, but changed the wording. That wording was never recorded, and it went just as it was, ratified as it was, even though states did not ratify it with that wording. So you can look through that, but this talks about the Constitution. Article 1, Section 9 contains a list of actions that are forbidden to Congress. In that list, Clause 4 provides, we're going to talk about the capitation tax. This is why it was struck down in 1895, an individual income tax. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. So what happened, a capitation tax is a tax or imposition on the person. Many people don't know what capitation is, but you know what decapitation is. It's where they take your head off. This is just a tax on your head. Not taking your head off, putting a tax on it. It's kind of the same in some regards. This constitutional prohibition means that no federal tax on the people or their earnings is allowed. See, the federal government is separated by the states that protects their citizens. The federal government could take a census and say to each state, okay, here's the tax. For example, Article 1, Section 2, Clause 3 says, representatives and direct taxes shall be apportioned among the several states. Okay, so this was a real deal. Taxes could be apportioned among the states, which may be included within this union according to their respective numbers. How do we find out their numbers? By the census. When that happens, the tax agency is the state. It's not the federal government. You don't have a federal IRS agent sending you a direct 1040. You have the federal government saying to the state of Maryland, as an example, here's your population, here's how much we need for the budget, this is the portion that belongs to your state, you figure out how you're going to get the money. The state may say, hey, I'm going to do an individual income tax. It's up to them. But the taxing agency is within the state, directly accountable to the people. Now the taxing agency is God knows where. Well, he does. He does know where, but the people don't, and that's the problem. How can we hold those officials accountable that are in the IRS? We can't. They're not voted on. But if it was the state that was responsible, we could eliminate. There are our neighbors. They're the guy that lives down the block. There's the guy that goes to coffee at the same coffee shop that we do. Keeps it locale. If you're irritated by the way that they proportion their taxes, guess what? You can form an allegiance with them to go to the federal government and say, this is not right, we're not living within our means, etc. Or number 2, you can remove that man. It's simpler. There's more accountability. This particular amendment, even though it wasn't intended to, has eliminated that. Tariffs were the principal means by which the federal government funded its work. Except in times of war, there was a direct tax during times of war. At times, the federal government apportioned the tax bill to each state, like I just explained. The states could stop any and every federal act contrary to the wishes of the state legislature. This was by using the senators, because the senators used to be appointed by the states. So there was just a stronger check. So if the states did not like what its senators were doing, they could recall that senator and appoint somebody new. Not anymore, because they're popularly elected. Once the people vote them in, we've got them for 6 years unless they're impeached. But prior to that, the state legislatures could remove and interchange a lot quicker if they were dissatisfied. Again, that was closer to the people. The people had a way to react and respond instead of waiting for the whole Congress to impeach a senator. So the original purpose of the 16th Amendment was this. It was an issue of trust busting. At that particular time, the Sherman Antitrust Act was enacted in 1890. Why? Because what was happening is that corporations were getting together, and different corporations in the same field would then create trusts together. And what they would do is they would start to monopolize and just dominate the market, and so thereby, there's specific wording to this, so I don't want to butcher that. Forgive me for just a minute. I can't find that exact wording, but what the emphasis of it was is that the people then were becoming victims to these trusts. So the people were being abused by the corporations. Essentially, is what's their liberties and their rights were being threatened by these corporations. So Congress enacted an income tax that imposed a tax on income of corporations in 1894. That was struck down as unconstitutional, like I said. That's just the corporations. In 1895. Listen, folks, this whole topic is very fascinating. I encourage you to read it in depth. If you don't grasp what I'm saying tonight, it gets much better, and it's very clear to understand. In 1895, in the case of Pollock versus the Farmers Loan and Trust Company, the Supreme Court declared that the tax on these corporations, these trusts, if you will, was unconstitutional because it imposed a tax on, quote, listen, income derived from property. So if I'm a farmer and I farm my goods, I should not be taxed. Because nor can the federal government tax me as an individual. It cannot tax my income, nor can it tax what I produce by my property. However, taxes were brought, so it'd be the same thing as real estate and things like that. There was other types of tariffs that were laid upon people that could be taxed. But understanding the Pollock decision, to tax income when the source of income was property imposes a federal tax burden on the property itself. The federal government has no jurisdiction over that property. Therefore, this is forbidden by the limitation on direct taxation in the Constitution, no capitation tax. Okay, it couldn't be on the person or property. Article 1, Section 2, Clause 3 provides, representatives and direct taxes shall be apportioned among the several states, which shall be included within this union according to their respective numbers. Okay, that goes back to the census and how the state determines it, but not upon specific property or specific individuals. President William Howard Taft, in his message to join his whole campaign was that he was going to come in and bust these trusts, because the Supreme Court was too cowardice to do it, and government wasn't acting smoothly enough, so he was going to come in, he was going to create wording for a 16th Amendment, this was his push, and you can find this in the congressional record, this wasn't hidden, this was out in the open, he was doing it the way that the Constitution prescribes, create an amendment, just like Washington said. His purpose, the function of the 16th Amendment was to assure the constitutionality, so we want to create an amendment that would agree with the Pollock decision that we just covered before. So there can be no tax upon the property or the income of a man derived from the property because it's a direct tax on the property. He wanted to come in and ensure that it would not get struck down by the courts, so he crafted the wording much better. He proposed a corporation income tax, which he passed in the same year, 1909, sessions of Congress. The amendment did not authorize any income tax on any U.S. citizen, though that's what it's used for today. In President Taft's letter, the message to the Congress, he called for a bill to impose a tax on only 2% income of corporations, not individuals. He prescribed this proposed corporation income tax bill as being, quote, in form and substance almost exactly the same character as that. The income tax law involved the Pollock decision of the U.S. Supreme Court, wherein the law was ruled to be unconstitutional. President Taft considered it unlikely the court would be willing to reverse the Pollock ruling. Of course they would. Therefore, in order to assure the constitutionality of his income tax on corporations, he proposed a constitutional amendment that would override the crux of the decision and assure the constitutionality of his new proposal. Court's opinion on the 16th Amendment, of course, it then did pass, although there's major problems with this ratification, which again is part of your homework to study those in depth. We've just covered them briefly. We've scratched the surface. The court's opinion on the 16th Amendment. So what does the 16th Amendment mean? What is the income tax? Does that mean we got to file a 1040 every year? No. And here's the problem. On paper, what we are involved in voluntarily is not what the law is. Plain and simple. The courts have even agreed upon that. This was in 1960, and the cornerstone decision relied upon by the IRS that established the constitutionality of the income tax, but only as an excise tax under the 16th Amendment. This case involved withholding monies accruing to non-resident aliens. Think about that, non-resident aliens. Now they get all the stinking benefits for coming over here. But it applied to non-resident aliens who were what? Not citizens, by the way. The court said this. The court explained the 16th Amendment states the tax authorized by the amendment must be laid, quote, without apportionment, And because the Constitution still requires that all direct taxes must be apportioned among the states, the income tax cannot stand constitutionally as a direct tax on the citizens. Because it's by apportionment. It's by all of the people together. Therefore, you have an amendment that would contradict the actual Constitution, and it wasn't meant to do that. The only way it contradicts the Constitution is if the people, through ignorance, embrace a new meaning that was never meant for the 16th Amendment. The court stated the income tax is constitutional only as an indirect tax in the nature of an excise. That means an excise tax is something on other than an individual or property. That's what an excise tax is on. So it's earnings made other ways, stock markets, capital gains, things like that. In 1916, the U.S., I shouldn't say capital gains, excuse me, that's not specific enough, but other forms of revenue and income other than individual income or income by property. In 1916, the U.S. Supreme Court held in Stanton versus Baltic Mylan, the 16th Amendment created no new power of taxation. In other words, the original power of taxation, no capitation taxes, found in the Constitution, was still there. What it did is it opened it up for corporations or for non-resident aliens to be directly taxed, but not individuals. Other Supreme Court cases have ruled that the income tax is an excise tax imposed on activities involving the exercise of a government-granted privilege, such as a resident alien enjoys, such as the activities of corporations or activities of non-resident aliens working or doing business in this nation, and that income is the measurement for determining the amounts of the tax for such corporations or non-resident aliens. Okay, so the way that you and I follow 1040 is perfectly upright according to the 16th Amendment for corporations and non-resident aliens. In 1918, the Supreme Court decision of Peck versus Colorado, blah, blah, the 16th Amendment does not extend the power of taxation to new or accepted subjects. Neither can the tax be sustained as a tax on the person, measured by income. How much more specific can we get? Cannot have an income tax, federal income tax. Such a tax would be by nature a capitation rather than an excise. And then we're making sure, Taft was making sure not to do that. The 16th Amendment was making sure not to do that, and all the courts have ruled that it cannot do that. Yet it does it. Capitation taxes are still forbidden by Article 1, Section 9, Clause 4 of the Constitution. Nothing in the 16th Amendment repealed or nullified the constitutional limitations on the imposition of direct taxes, which still prohibits the imposition of any federal taxes on individual citizens of this country or on their property. If you look at the language on the 21st Amendment, as it specifically states, the 18th Amendment is nullified. In order for the language of Article 1, Section 9 to be nullified, the 16th Amendment would have had to specifically and clearly been stated that as the 21st Amendment. So in other words, we would have had to say, if the 16th Amendment's purpose was to nullify Article 1, Section 9, it would have been written in there to say, listen, that's what we used to do, we ain't doing it anymore, here's the amendment. This was understood to be very limited tax. Also, okay, now that aside, the constitutionality of it, I want you to understand what we were talking about when we were talking about taxes in 1913, okay? A standard exemption for a corporation was $4,000. So if you made $4,000 or less, you weren't even in the ball game, no filing, nothing. That in today's 1994 dollars is 60 grand. You made 60 grand, don't even bother. Those making less paid no taxes, of course. After deductions were subtracted, the tax on the first 20 grand of income, which in today's is about $300K. So if you made $360,000, first $300,000 in 1994 dollars was 1%. You paid 1% federal income tax. In addition, those who were very wealthy paid a graduated super tax, a Communist Manifesto, by the way. Those making $500,000 or more in 1994 dollars, that's $7.5 million a year. That's how much you would have to make to pay the super tax, which is a whopping 6%. So if you made less than, if we go back to $1994, again, that's 20 years ago, 20 years ago. You made more than 60K. I don't know what today's due to inflation, whatever. I don't know what. Didn't even pay tax. If you did above that up to 300K, you made 1%. If you made 7.5 million, you paid a whopping 6%. That 7.5 million guy now is paying 50. Well, considering all of his taxes. The federal income tax has served as a vehicle of tyranny by confiscating the people's money by central government and returning it to the states in a manner that coerces the states to be the agent of federal tyranny. What did the Fed do with all of those tax dollars? Well, they redistribute it to the states. And then they say to the states, if you do this, you'll get these federal dollars. But if you don't do this, then you don't get those federal dollars. That's coercion. But that's what's happening right now. Using our very own money to tyrannize us. And that's what happens in judgment, Deuteronomy 28. And George Washington knew it when he swore his oath over the Bible and said, so help me God, that I don't participate in a system that would corrupt our moral character and being before our heavenly God, and so inherit the curses of God located in Deuteronomy 28. The 17th Amendment, senators popularly elected. Before, remember as I said, the state legislatures would choose the senators. Now they're popularly elected. If the state legislatures could choose their senators, 2 of them from every state, the state had power in Congress. They didn't like what the senator did. Recall, put a new guy in. But they had voting power. Nowadays, it's not the case. The states, we've turned into an individual accountable to a federal government instead of a federal government accountable to the states, who is then accountable to the people. It's turned the other way around by the 17th Amendment. It eliminated an important state check on federal power. You can also research Bill Benson, who was the one who said about the 16th Amendment was not ratified correctly. The 17th Amendment was not ratified. Proof the 17th Amendment was not ratified is another research paper that Bill did. The 18th Amendment, 1919, this is the prohibition of alcohol. Again, this many people have argued that the federal government had no jurisdiction in this. The Bible does not speak of, which is the source of law. It says, do not be given to wine, in other words, to become obsessive, to drunkenness, etc. It does not prohibit alcohol or the creation of alcoholic beverages, but it does give the parameters. Now, that's a self-government concept found in the Bible, or a family government. Now, the states could handle this. Many states had already made it illegal to do the prohibition and the sale of alcoholic beverages, etc. But if the federal government came in to do this, now this is the problem. When the federal government does something that's good, it doesn't make it constitutional, nor does it make it, well, we're going to cover that. This amendment gave the federal government authority over a matter of law enforcement that was better left to the states and the family government. The powers delegated by the proposed constitution to the federal government are few and defined, said James Madison. Those which are to remain in the state governments are numerous and indefinite. So this was clearly one of those issues. The 19th Amendment then came along afterwards. I'm going to come back and cover the 18th Amendment, but for right now I'm going to move on because the 18th Amendment was later amended, if you will, or eliminated by the 21st Amendment. But the right of the citizens, this is with the women, the right to vote cannot be denied based on sex. This was already true in some states. But the federal government came and said this was a dissolution of the franchise to vote and reduced the influence of the family government, checking the power of the civil government. Now, I want people to understand this more clearly. Some people say, well, we're denying women the right to vote. And do I believe women can vote? Yes. Do I believe women are very competent? Yes. But let me help understand, perhaps, the power of the family. Family was represented through a vote. The man was the representative to cast that vote. Now, many men are ungodly, unbiblical, and I spoke to a man about it today. Even Christians can become that way. If a family who's represented by the man of the household casts a vote, the family is united, similar to when the states elect the senator. If now you have a man and a woman, both in a family, both casting a vote, that family could be united. Maybe they're both voting for the same person. Maybe one's voting for one and the other one another. They cancel out. I'm just showing there's kind of a beginning of a separation of that family government there. But and I don't mean to step on anybody's toes. Hey, there's many households where the man is not present because he's a stinking loser. So the woman is every bit capable to vote, to do the research, to experience the liberties of the tyrannies of the laws of which she should be able to vote for. I'm not saying that. I'm not taking that away. But just giving the understanding of the family was an understanding that I hadn't been aware of before. The 20th Amendment was the presidential succession. This is the terms the president and the vice president, when they would take office. It was January 20th instead of March 4th. Obviously, back in the day, it was horse and buggies. It wasn't very easy to move things, so they need a little extra time for the new president to come get moved in, etc. Not the case nowadays. Improved transportation, blah, blah. This also reduced the opportunities for lame duck presidents and congressmen to exert last-minute influences. The presidential succession was altered again. If you see Lecture 7, it was altered numerous times. The 21st Amendment, 1933, prohibition was repealed. Now, I want to read this. Section 1, the 18th article of amendment to the Constitution of the United States is hereby repealed. Specifically said it. Look, 18, done away with. Section 2 says the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors, comma, in violation of the laws thereof, comma, is hereby prohibited. What laws? See, what happened is there was an agency assigned, of course, just like with Obamacare, there's more extra IRS agencies. Who's going to be in charge of ensuring that these rules are followed, this law is followed? I have the Alcohol, Tobacco, and Firearms Agency, in essence, that was created. Why? To make sure that nobody was bootlegging, etc., etc. These are the federal agencies that was created, like the Department of Homeland Security or the TSA, Transportation Security Administration. These things were created. Now, you would think when we got rid of the 18th Amendment that the agencies that were in charge of enforcing it would have went with it. Not the case. By the wording here, this article shall be inoperative unless it shall have been ratified as an amendment by the Constitution by conventions in several states, provided in the Constitution within 7 years from the day of the submission hereto of the states to Congress. The 18th Amendment was prohibited. It was not popular, and juries were nullifying government prosecutions already. This is part of the reason why it was nullified. However, enforcement authority over violations of state law seems to be retained by Section 2. So the agencies still remain. Despite the repeal, the IRS and the BATFE remain. Something that you can watch. This is obviously something you can get, the Jews for Preservation of Firearms Ownership. If you go to thegangmovie.com, I believe it's in your notebook as well, The Gang, like a gang, G-A-N-G, movie.com, you can understand just about these laws and things like that, and these agencies, excuse me. The 22nd Amendment, 1951, was a 2-term limit for president. Why? Because Franklin Delano Roosevelt, during a crisis, the Depression and World War II, but when FDR died a few weeks into his 4th term, Americans decided to make the 2-term tradition a solid rule. The 23rd Amendment, 1961, was District of Columbia electors. The District of Columbia, they have license plates to say taxation without representation. They have no federal representation in Congress or Senate. However, they can vote for president. They have the electorals equal to the number of the electorals from the least populous state, which is 3. Because generally states have 2. All states have 2 senators, and many states don't have a population large enough to support 1 congressperson. So, there you have it. The 24th Amendment in 1964, a poll tax amendment. This is speaking about the poll taxes that were usually $1 or $2 in order to vote. You had to pay to vote. Well, then people would say, why do I have to pay to vote? I have to pay to protect my rights? Well, in most cases, these polls, the money was used to cover the cost of the polls. The cost of elections, the booth, the people, the electricity, blah, 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 the pencils, the documents, the counting, etc. But It was also used in the South quite a bit to deny certain people based on prejudices their right to vote. So that was amended. No more poll taxes. The 25th Amendment, presidential succession. Again, it's revised. Look back in Lecture 6. The 26th Amendment, 18 years old to vote. Now, what this does is set a limit. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. The Congress shall have the power to enforce this article by appropriate legislation. There it is again, just slipping in that wording there, saying, "We're your daddy." But the right to vote shall not be denied on the basis of age for anyone who is over 18. Now, this does not prevent a state from setting a voting age of less than 18. It's just saying, listen, if you are 18, you cannot be denied voting. It doesn't say if you're 16 or 15 or 14. It doesn't speak to that. It's just telling the states, listen, you can't set a voting age of 21. Voting is now increasingly seen as a universal right. So now, in a particular household, you could have a mother, a father, and children voting differently. Now, I'm not saying bad or good, but what I am saying is that household is now divided 3 different ways. So you can kind of see a separation and I would just say a separation of the family in some respects. Voting is now, here's what I'm getting at, though, more specifically and precisely. Far more important than what I just expressed. Rather than a means of protecting rights and a privilege to be exercised by those who can vote responsibly, by stakeholders in the administration of justice, and by that I mean people who have skin in the game, the dilution of this franchise leads to an increase of legal plunder. What does that mean, Jake? Well, you should know, because we all read The Law by Frederick Bastiat. That was our homework some time ago in one of the lectures. Consider this. Once a group finds that it can get from government, it can receive from government, and they're going to increasingly, polarize their numbers, put them together, and go to get. The problem with that is that those putting nothing into the government have an ability to pull out of government. That's theft. They haven't put anything in, yet they demand something out. That is theft. You or I would be arrested if we attempted to do that. But now, because of the way that the voting franchise has been diluted, you have one group of people voting only for what they can get, not for protecting their rights, for what they can get. And when that happens, how do you have equality? How can you have equality? You've got one party who's voting on something that he has a stake in. You have another party voting on the other man's stake, literally. 27th Amendment in 1922 was actually regarding congressional pay raises. Now, this was originally it was one of the original first 12 amendments that Madison took from all the states, put them together. It was one that was not ratified, however. And this particular one, by 3/4 of the states, I should say. In the 1980s and the 90s, people became upset with congressional pay raises. And interest in this amendment was renewed. It was ratified. So in other words, they didn't create a new amendment. They just looked back and said, man, maybe Madison was right back then in the 1700s. So a couple hundred years later, in the 1990s, this particular amendment was ratified, the 27th Amendment, even though it was original. The funny thing is Article 5 does not specify how much time needs to elapse before 3/4 agree. So it stayed on the table, but 3/4 of the states did not agree on it or approve it until a couple hundred years later. So right now, 204 years to be exact, the 27th Amendment was certified by the director of the U.S. Archives as, yes, this is legitimate, it's constitutional. So now we have the 27th Amendment. Now I encourage every one of you, through the homework assignments that we have here, just give me 1 second here as I pull this up here, because I want to make sure that I've also got all the correct information for the rest of this class when it comes to your homework. Bear with me. Boy, a second seems like an eternity when you have a camera in your face. Yeah, we went through that. Okay, yeah, that's all done. Okay, super. Your homework you'll see right at the back of your lecture. Take the review, go through that. You can correct it by yourself because the answers are literally text. And then we will begin with Lecture 10 test next Thursday at 7 p.m. Central Time. I hope if there's any questions, you can Facebook me right now. Let me know those. We can cover them with everybody. Otherwise, you can do it privately. Many of you do after the class. You'll send me a Facebook message or an email. And I welcome that, encourage that, and I thank you for that. That interaction is important. And I also encourage you, as time ticks down on this class, if you're wanting to take it again, get in contact with me. I will let you know. We also offer courses through the Institute on the Constitution regarding the jury. We have a Federalist, Anti-Federalist. We're literally studying that and covering that. As a matter of fact, that's happening upstairs right now in our offices, where there's a course dealing with those particular those papers specifically. So as you get through the U.S. Constitution, we also have a sheriff's course and talking about local government and keeping them accountable. So there's just a tremendous amount of resources here that we can share with you, and we'd love to share with you. If there's no more questions here, I'm going to shut it down. I will send everybody the YouTube link so you can cover it again. God bless you all. Have a great weekend, and love your country, serve your God, and let's take it back. God bless you.